Yay, oh yay, oh yay. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, it's nice to open our session this term in Baltimore, University of Maryland. We haven't been here in a little while, and we really appreciate the hospitality. Welcome the students here and anybody else. Our plan is to hear these three cases. Then we will conference them briefly, and we can explain later what that means. But that basically is to have a preliminary discussion as to where we'd like to go on it. And then we'll come out and be willing to answer questions and have a discussion, an informal discussion to the extent that any of you wishes to do that. First case, I guess we'll hear from Ms. Kwong. Who's first?
Good morning. May it please the court, Teresa Kwong for the United States. To succeed on a claim for a failure to accommodate under the Fair Housing Act, plaintiffs had to show
Is there a speaker there?
It's not working.
No.
I'll stand closer. Would that help?
That's good.
Okay. To succeed on a claim for a failure to accommodate under the Fair Housing Act, plaintiffs had to show that their request to waive the business purpose restriction was reasonable and necessary to provide individuals with disabilities an equal opportunity for housing. GIC moved for summary judgment, arguing that plaintiffs failed to show that the accommodation was necessary. GIC did not move on the reasonableness prong. Under the necessary prong, the district court should have considered only whether the waiver was necessary to provide an equal opportunity for housing for persons with disabilities. Instead, the district court looked at the conditions that GIC set forth in the MOU and required plaintiffs to show that removing the disputed conditions was necessary to provide an equal opportunity for housing. That was error.
GIC understand the request for accommodation was responded to by Gibson Island Corp. With 23 conditions, right?
Correct.
And 19 of them were agreed to.
Correct.
And 4 were not agreed to.
Correct.
So why are we discussing the conditions that were not agreed to at all? In other words, it seems to me the assessment under the FHA is to look at the accommodation and see whether it meets those 3 criteria: reasonableness, necessity, and so forth. And instead of looking at the requested accommodation as amended by the 19, the district court got off on the conditions and assessed those, and it seems to me they're irrelevant.
You're correct. You're entirely correct. I mean, this is a case where—
So as a consequence, we never got an analysis on the reasonableness.
That is correct.
All right.
I mean, you summed it up perfectly, that what the district court did wrong. Although the defendants raised the summary judgment motion only on the necessary prong, all their conditions, all the arguments they had were arguments that pertain to the reasonableness prong, that their claim that the waiver would impose substantial administrative and financial burdens on the defendant. And even though they put all those considerations under the umbrella of the necessary prong, the district court should have considered those conditions as factors under reasonableness, and it actually could have just said that you didn't show genuine issues of I'm sorry, what were you saying?
I was just wondering if you could tell us who, in your view, bears the burden there of production. Once it's established that there's a need for accommodation, who bears the burden?
The defendant bears the burden. So in the reasonableness analysis, the plaintiff shows that their requested accommodation, the waiver of the business restriction, was reasonable. And if the defendant has a claim that the accommodation would impose burdens on it, it is obligated to come forth with a burden of it's obligated to come forth with some support for that claim. And that's nothing new. That's actually what happens in practice. And that's what happened in Scoggins. In Scoggins, this court noted that the defendant provided overwhelming evidence showing that the requested accommodation was unreasonable. And that doesn't mean that there is a burden shifting. The plaintiff maintains the burden of persuasion, but it makes sense for the defendant to have a burden of production.
Counsel, can I ask you a question? Assume hypothetically, I agree with you that the district court misunderstood the necessity inquiry. What do you want us to do? Do you want us to find that this accommodation is necessary as a matter of law? Do you want it to go to a jury, or do you want us to send it back to the judge to look at it again?
I think you should send it back to the judge because the judge just misapplied, considered the wrong thing.
I know,
in
but
the
how
reasonable
hard is it to
accommodation.
figure out? Do we really need to remand on this? What would be the plausible argument that it's not necessary? There's no other such home on Gibson Island.
I actually think you could find as a matter of law, there is actually no alternative to the request for a waiver because there's no alternative to waiving this restriction that would enable the plaintiffs to operate a home for senior citizens with disabilities on Gibson Island. But I think if you would need to still remand for the district court to consider the reasonable.
Oh, sure. I'm sorry. I just meant on necessity. What do you want us to do?
I think you could just say that as a matter of law, there is no alternative. I mean, there's no way for the plaintiffs to operate this home without a waiver of the business restriction, but that the district
It
court would
seems to
need
me that we've got everything upside down. The necessity argument addresses the accommodation, whether the accommodation is necessary. But the gatekeeper is whether the accommodation is reasonable vis-a-vis the island. So if we had a request to put in a 10-story veterans hospital for the disabled, that might not be reasonable in this residential community.
That's correct.
Whereas other interim sizes may be reasonable. We had zero analysis. The question is, do you have to put in a Walmart on a residential area? I mean, that's the type of inquiry that has to be made, and we just don't have that record.
And I think that's correct. And it's exactly what happened in Brightwood's Inn, although the court said the bulk of the decision rested on the necessary prong. The court actually did go through reasonableness and then necessity. And that's what the 11th Circuit said in Shaw, that you should determine whether the requested accommodation here, the waiver request, was reasonable before you jump to consideration of the defendant's objections and counter proposals.
I have a question about the necessary prong. I know that there's no accommodation for people with disabilities or the elderly in terms of a group home on Gibson Island. But if there was a home, for example, right across the water on the shore that could easily be reached from Gibson Island, would that satisfy the necessary requirement?
Well, I don't think so, because the statute actually provides that an equal opportunity for housing of the plaintiff's choice. So the thing is here, what you have to ask is whether the waiver was necessary to operate the home on Gibson Island. There's actually no contention by GIC that a waiver was necessary in order for plaintiffs to operate their
I
home.
thought there was a way I construed the covenant was that this is a residential community and that no business can be put in there without approval of the board. And obviously, in making the assessment of a business, you have to look at a bunch of factors in the context of a residential area. And it seems to me we don't have that analysis. I mean, this may be a very reasonable use in a residential context, whereas the 10-story hospital may not be a reasonable use in this context. So it seems to me that case ought to be made. The problem in this case, as I see it, is that the analysis would have been fairly straightforward, but for the fact that there was an animosity between the plaintiff and the Gibson Island Corp. I mean, there was a personal relationship that colored everything. And I don't know whether that's a legitimate role or not. Gibson Island was worried about being sued continuously. There are some anecdotal facts that make this plaintiff sort of difficult to deal with, it seems to me, maybe, if it's true. But I don't know if that's a legitimate factor, but that clearly seemed to have played a role in the history of the transaction in this case. But I see we've gone over our time. Why don't I hear from Mr. Klepper?
Okay, thank you so much.
May it please the court. I'm going to focus on the one and only small area where we disagree with the Department of Justice. We are here to focus, or I want to focus on our cross motion for summary judgment and why this court should remand with directions to grant the June 2020 accommodation as a matter of law. The burden shifted.
Just to address that just briefly.
Yeah.
There was no argument or analysis on the reasonableness. And it seems to me the entire case, when you go into a residential area with a proposed business, and there's a covenant on the land which says you can't put businesses here without the board of directors waiver, it seems to me then the request, you have to assess first whether that's a reasonable accommodation.
Well, Your Honor.
So, and if we have my hypothetical, the 10-story veterans hospital taking care of the disabled veterans there, somebody may say that's unreasonable. There's too much traffic, maybe the burdens on the utilities and so forth. But maybe this is fine. I don't know. But the record does not address it. The court didn't address it.
This record perfectly addresses this, Your Honor. And the last time I was up in front of this court in May, I was telling the court, please don't decide this in the first instance. Please remand. And the court said, we can watch this video for ourselves. The application of the law is clear to this record. And they affirmed the conviction against my client. And they said, we can decide it. And this is going to be another, the question is
to review the district court, not to supplant the district court's role.
But review the summary judgment record, Your Honor, because the conditions that you noted, and this is following up on Judge Harris's question, the conditions that they attempted to impose were unreasonable as a matter of law. First of all,
you're going right off where the court went. And I think that may have caused the court the problem. The conditions have nothing to do with this. The conditions that were agreed to are modifications to the accommodation request. The conditions that were not agreed to are irrelevant because the accommodation stands as amended by the agreed to. We're not talking about conditions. We're talking about whether the requested accommodation was reasonable, was necessary, et cetera.
well, but however, in that proper analysis, Your Honor, it would shift to the undue burden. And the undue burden that they're trying to alleviate that they have said was the septic condition and the Lucy as burden conditions. And those are wherever they fit in the analysis.
They turned it down.
Yeah. Oh,
I mean, why does it matter that we look at why they turned it down? They could have turned it down because they don't want anything.
But Your Honor, so for example, you talked about the Mr. Lucy is difficult issue. Now, if that is their defense on, because this is their defense on summary judgment under Maryland law, they actually bear the burden because they did reject Bryant Woods and say that once we made the prima facie case, the burden shifts on persuasion. So this is not a condition that applies to any other property. No case has ever held that's a valid consideration, nor could you, consistent with the Fair Housing Act, say that a requester being a personally difficult person is can be an undue burden, because people who are trying to build group homes where none currently exist are invariably viewed as troublemakers. And I get it. You look at his emails and his emails look like a pro se file, right? And it's like, this is hard to read, you go through. But no problems when he testified orally. And this is in the record. My client, Mr. Lucy, has ADHD. He received an accommodation at the University of Virginia to take his exams orally because this is what his written product looks like.
Mr. Klepper,
Yeah.
the district court also ruled against you on summary judgment on both your FHA retaliation and discrimination claims.
Yes.
Can you explain your theory in your retaliation claim and what evidence was presented to create a genuine issue of material fact on that claim?
Oh, on that claim, Your Honor, I mean, what we are talking about here, they refer to in the record as having what is it? The asymmetrical and unfair fight. They refer to a multidisciplinary approach, legal and extra legal. This is what they put in writing. And they said, how about we recruit the Waltons which is to harass them personally, What if we get the entire community together? The island is littered with "Screw Lucy" stickers. The stop signs say "Stop Lucy" underneath them. People have added those.
Were those signs created and distributed by the defendants?
It was encouraged by the defendants.
Is there evidence of that in the record?
There's the evidence in the record is, yes, extra legal approach. They talked about it. They talked about recruiting his enemies. This is harassment. And on that point, Your Honor, I would like to refer you to what is this? It's the playbook. This is the Kathy Frederick email at Joint Appendix 1783. This, on that point, what happened was, this is President Daley, and he is emailing back and forth with somebody who is a veteran of fighting the Shepherd Pratt expansion into the Ruxton neighborhood. And what she said was, we were able to slow them down with parking restrictions, regulations, matters like that. But where the real victory was? Shepherd Pratt said, had they known there would be such intense community opposition, they never would have tried to do that. They managed to deter Shepherd Pratt from ever doing anything like that again. So Shepherd Pratt would never try to do a second group home in Ruxton. And Mr. Daley responded, great, we'll do our best to defend our deeds and easements versus the Fair Housing Act. This is designed. This entire campaign is designed, and a jury under 404B evidence, Your Honor, could very easily find that.
Counsel, can I ask you a question
yeah.
about the way the argument you're making now
Yeah.
and the reasonable accommodation argument fit together? Your view is that there's enough evidence to go to a jury on the theory that these conditions are pretexts for discrimination or for retaliation. If that's right, that would make them kind of per se unreasonable as reasonable accommodations. So how come they are jury questions when it comes to discrimination and retaliation, but you think you can get summary judgment that they are unreasonable as a matter of law?
Thank you, Your Honor. In the accommodations context, the pretext analysis would be, there is case law, I'm blanking on the case at the moment, that even if you have found that facially there was these burdens were okay, there might be a jury question. However, these are unreasonable as a matter of law where I don't even need to get to that. You don't need to show animus. You merely need to show it should have been granted. It's the worst case scenario for us, Your Honor.
Just so I'm clear, what is it that makes them unreasonable as a matter of law that is not related to the alleged discriminatory or retaliatory intent?
This would be the county saying, no, this fully complies with the building permit. And they told that to Gibson Island. And Gibson Island is simply trying to re-urge those same arguments in this court. And there's Maryland case law.
No, okay, so the septic provision unreasonable because the county said you don't need it.
Yeah.
What about the other conditions?
The other ones, so no case has ever held that a request for being a difficult person is a valid consideration. And
But this is what Judge Niemeyer was talking about, I think. Why don't you think we can just find as a matter of law, under no circumstances can this kind of condition ever be attached?
Okay, first of all, yes, you could find that because any such condition would be not consistent with the Fair Housing Act. However, on these facts, if this court wants to go further, so Judge Berner, you asked about what if there were another home right outside the way? Well, there is another home. There's the Mountain Road spot, which is, so to get to Gibson Island, like about a third of a mile before you get to the gate for the gated community. That is where the Mountain Road facility was. And the Windmill Point, the folks on the other side of the security gate, they were coordinating with our clients to block group homes anywhere.
But I'm sorry, and I'll let this go in a minute. If I think we can say this record compels that judgment, it's the only way to read the record, then I don't understand why you think you have to go to a jury on discrimination and retaliation. It seems like you're making.
Your Honor, you could actually find as a matter of law that there was a discriminatory intent here.
Okay.
We did not move for summary judgment on that aspect. So I am arguing what our cross motion for summary judgment argued. It also wouldn't, in terms of the jury verdict on the damages, it wouldn't advance the ball necessarily because that evidence would also go towards the delay damages and potentially punitive damages on the discriminatory treatment claim. And so all of that would be going to the jury anyway, the same evidence. So it doesn't, as a practical matter, advance the ball. What advances the ball, Your Honor, is to make sure we don't have to wait another 2 to 3 years for this, for the work to actually begin under the building permit. Because a delay for 2 or 3 years so that this can wind through again is denial for another 2 to 3 years that there is another 2 to 3 years that there will be no facility whatsoever on Gibson Island for this purpose.
All right, I think I see you're going.
I've
for
gone
red
over.
light.
Thank
Yep. All right, Ms. Tobin.
Good morning, Your Honors, and may it please the court. I'd like to begin by sharing with the court the language of the accommodation that was actually requested by appellants. And it states, and this is at Joint Appendix 1955, my clients presently request that the corporation grant a reasonable accommodation in the form of a waiver or modification of the business purpose restriction in subdivision 3 of the deed covenants to the extent necessary to permit them to operate an assisted living group home for 9 seniors with disabilities at the Banbury property. That is precisely what the corporation offered the appellants, is an accommodation that consisted of a modification of the business purpose restriction such that it enabled the plaintiffs to operate an assisted living group home at Banbury for 9 seniors with disabilities. As a result, the plaintiffs failed to make their burden that the defendant refused the accommodation that they requested. And therefore,
I think that's really a difficult argument to make. The Gibson Island Corporation attached 23 conditions. During the negotiations, 19 of those conditions were agreed to. So at that point, the accommodation request included the initial request plus 19 conditions agreed to. Otherwise, they didn't reach agreement. And they probably can't reach agreement. I mean, it looked to me that the lawsuit itself was an indication they couldn't reach agreement. At that point, it ends. The accommodation has been denied because Gibson Island will give it only on the 23 conditions, and they only got 19. The plaintiffs say, we only want the 19 conditions. And it seems to me the whole case should turn on the reasonableness and necessity and the standard we apply to assess the accommodation as amended by the 19 conditions. And if it turns out that it is reasonable and necessary for that, I mean, I understand the necessary thing not to be as big as everybody's making it out to be. It seems to me, if you have a disabled house and you take away the stairs and put on a ramp, that would be necessary probably for the house, and that would hardly be a big deal. And that's really the nature of the changes in this case. The bigger issue that seems to be, there's 2 issues, I think, lurking. One, a real one, and the other one, probably the legal one. The real one, it seems to me, it's a personal relations problem. But the real one is that the accommodation was unreasonable, and nobody addressed that. If it's reasonable, it seems to me they're going to get the accommodation. FHA requires it. What goes into the reasonableness is a lot of, it goes into all these factors, but it does not look like Gibson Island Corp is that much opposed to it on a pure reasonableness basis. But we didn't get that analysis. We get this whole record and fight and arguments about the conditions, which are irrelevant because they were never agreed to. So you have an accommodation request. You look at the accommodation request, analyze it under our case law. And that's really where we should be on this. And if the accommodation is unreasonable and not necessary, then Gibson Island can continue with its position. On the other hand, it sounds to me like Gibson Island would agree to this. There are a lot of statements to indicate this is not that much of a business intrusion. It's not like my hypothetical But I raise that hypothetical just to point out that there's a whole spectrum on reasonableness. And we haven't addressed that. And that's clearly got to be established. And it's a factual question. Maybe it's a factual question, maybe not.
So there are a number of cases, including Bryant Woods, who assess conditions and alternatives under the necessary prong of the analysis. And that's exactly what the court
But we're
did
not
here.
arguing the conditions. They never agreed to them.
Well, and
The conditions just represent the reasons you denied it. But the reasons you denied it should be assessed under the three-pronged standard: reasonableness, necessity, and the promotion of the.
And with respect, Your Honor, we didn't deny it. What we approved was an accommodation that would have enabled the plaintiffs to have a group home at Banbury for 9 persons with disabilities. Then the question became,
I think that, in fact, we learned in law school, I think all the students here know that when you have a counteroffer, then there's an offer and then a counteroffer, then that is a denial. And so there's no contract, there's no offer, there's no acceptance. It doesn't seem to me that you did accept. It seems to me that you said, no, you have to agree to these other conditions, which at least 2 of them seem to violate the FHA in and of themselves, to place a financial condition, to place a waiver of your right to go to court. And so that there was no actual agreement.
and I'm not aware that the cases require that there be agreement. The cases require that the defendant either offer to approve an accommodation or that they don't refuse an accommodation. But I am not aware of cases that require that the parties have an agreement. Otherwise,
Well,
these
an
issues.
acceptance. You say that there was an acceptance.
You don't need an agreement. What you need to do is assess the requested accommodation. And the requested accommodation did not include those 4 conditions.
The requested accommodation included the opportunity to modify the business purpose restriction.
Right.
And-
They
and-
asked for a waiver and they laid out a bunch of details as to what they were going to do. And you guys requested 23 conditions, 19 of which were agreed to.
That's right.
Now, it seems to me, when we're assessing whether that accommodation is reasonable, we don't assess why you turned down the other, or why they didn't accept the 4. That isn't the issue. The issue is whether they're entitled to go ahead with that accommodation based on the analysis we set forth, beginning with number 1, was it reasonable? And that was never addressed.
And
Conditions keep sucking everybody into some discussion which is irrelevant. That goes to the motive as to why you guys turned it down or they didn't take it. I mean, that arbitration condition is really, I've never seen anything like that. $100,000 deposit.
Well, there's a $100,000 deposit that is a mutual deposit as a precondition to initiating arbitration.
I understand.
So
We
it's-
don't need to get into it because I don't think that's relevant to me. What's relevant is the fact that the accommodation that they submitted and that they agreed to modify on the 19 conditions, that's the accommodation on deck. And that accommodation has not been approved by the association. The association insists on 4 more conditions. They say they won't agree to them. So we're stuck with their requested accommodation. And so the only question is, let's look at that and see whether that meets the standard.
Your Honor, looking at, I understand your perspective that the conditions are irrelevant. Our view is they don't come into the analysis in the same way because they're not related to disability. And the law is clear
Counsel,
that,
can I kind of move you
of course,
along? I want to ask about the district court's analysis of the record. And the district court says several times that it absolutely cannot be disputed on this record that this septic condition was intended only to address environmental concerns. Is that the way you read the record?
it is, yes.
Okay, let me ask you about a couple of things. It's a completely novel condition. You've got emails back and forth with the Gibson Island president about how you could use septic permits to block the home. And then you've got, as your colleague pointed out, the fact that Gibson Island goes running to the County Department of Health and says, we want you to revoke their septic permit because we don't think it's good enough, and the department comes back and says, we're telling you again, it's good enough, it's adequate. And you think in light of all of that, no reasonable jury could have questions about why this condition was imposed?
Yeah, I don't think that the record shows that the corporation went to the county and asked them to revoke the septic covenant that existed and ran with the land here. After the district court early in the litigation granted the corporation's request for an injunction, it issued a cease and desist order to the plaintiffs to stop construction on the home until they had sought and received a reasonable accommodation. Because of the court's ruling, the corporation went to the county and asked them to revoke the building permit as to the home in general, but not specifically
But the
as to the
county
septic.
comes back and says, this septic system is adequate. We know you think it's not enough for 9 beds, but it is.
Yes.
And in light of all of that, you think a jury could not have questions about why this septic provision ended up in the memorandum of understanding? Because it's hard for me to see how a jury could not find this pretextual.
My understanding of the district court's ruling in that respect was that the septic condition did not prevent plaintiffs.
No, I'm
from-
talking about the several times that the district court says no reasonable jury could question the motive behind this provision. And I'm asking you, and I mean, I think you've said you agree, and we can let it drop. I'm giving you a chance, if you want, to say whether or not maybe you want to walk away from that a little bit and explain why it's not necessary for you to win.
Well, I may have missed the last part of your question, but
I wonder if you have an argument. I'm just giving you a chance, argue
Yes.
your case however you want, that whether that is right or wrong, we should still affirm the district court.
yes, I think you can affirm the district court on the following basis. The plaintiffs had the burden to show that they could not serve persons with disabilities in light of the 4 disputed conditions. And plaintiffs
So
didn't.
what if one of the conditions was, you can build your house, but we want it covered in gold leaf? The plaintiffs would not be able to show that they can't serve elderly disabled people in a house made of gold. And on the district court's understanding, and I think yours too, doesn't matter. It's not necessary. We don't get to reasonableness.
No, because the plaintiff in that circumstance could show under the law that the condition wouldn't make it financially viable to be able to operate the home.
But at least under the district court's analysis, you wouldn't get to that question because it's not necessary that a house not be made of gold in order to serve the community that is intended to be served here.
But I think the district court's analysis went further and said that the plaintiffs had failed to show that the condition would prevent them from being able to operate the home.
Same with a gold house.
but-
That condition does not prevent them from being able to operate a home.
No, but they have the burden to show that the condition makes it financially viable or financially not viable or otherwise impossible to serve the persons with disabilities. And they haven't made that showing here. That's what the district court, as I read the court's opinion, found. There was a lack of evidence to say that the septic condition or the arbitration provision prevented the plaintiffs from being able to operate the home. That is my reading of what the district court found on that particular issue. Likewise with the arbitration issue, the plaintiffs have the burden. They could and should have shown that these conditions that they claim are unreasonable weren't actually something that would get in the way of them operating and serving persons with disabilities. That is the focus of the Fair Housing Act. How are the plaintiffs able to provide housing for people with disabilities? And here they made no connection between their ability to operate the home and the 4 conditions. And that's where the district court, I think, rested the decision.
Is there evidence of the motive or the purpose of the Gibson Island Corporation's conditions? Is there any evidence that this was because disabled persons were being served? It seems to me the record's pretty thin on that notion. It looks to me what is driving this dispute is the personality conflict. And the president said explicitly that if somebody else had made this request, we probably would have approved it or something like that. Where does that lead?
I agree. And that's why this is not discriminatory as to persons with disabilities. The
It doesn't
problem,
make the first part go away, does it? The waiver issue? In other words, we have three components in this case. One is the request for accommodation. And that is just a rational analysis of the accommodation under the three components that we've established in law. The second is discrimination based on home. And that there, to me, there seems to be, the evidence seems pretty thin. I'll ask the other side on that too. But the evidence seems to be pretty thin. And then the retaliation, you've already heard some comment about that. But it seems to me this case should be a straightforward assessment of the accommodation request under our analysis. And I must say, based on the record, it looks like you guys will probably make an accommodation under that assessment. But I don't think we need to go into why you turned down the accommodation with those four conditions. That's just motive. And if those motive is because the people were disabled, that doesn't appear. Those conditions relate to the personality of the person you're dealing with because he's litigious. And so the discrimination seems to be a different issue. But I must say, with respect to the first count, I thought everything got off track.
I agree with your characterization of the evidence of intentional discrimination. It is too thin, and the court was correct to grant summary judgment in the corporation's favor on that count. And with respect to retaliation, they have a real standing problem.
Well, I don't understand the standing problem. I thought the inquiry, and I'm just wondering if there's any case law to support the position that the district court adopted. The inquiry under retaliation is whether the action would deter an objectively reasonable person from, in this case, continuing to advocate on behalf of the disabled and the FHA. And I just don't see how it can be that if you target Lucy, that doesn't deter the LLCs and vice versa, because it's all the same person and all the same decision maker. Like, obviously, targeting Lucy will deter the LLCs. I don't see the problem.
Yeah, below what the plaintiffs relied on for their retaliation evidence was some of the personal issues with
Right.
respect to Mr.
But how does
Lucy.
that not deter the LLCs from going forward with this project, given that it's Mr. Lucy who's making the decision?
Yeah, I think that what the court correctly found was that the corporation, the two entity plaintiffs, didn't have the ability to bring the false light portrayal
Right.
issues
Right,
on
and I guess
his
I'm just
behalf.
asking you why that is right, given the point of retaliation being about, for instance, if a parent calls a public school to complain about treatment of her daughter and the school responds by taking adverse actions against the daughter, that obviously has a chilling effect on the mother. And I've never seen any kind of retaliation case law that would split the atom the way you're suggesting here.
Yeah, and I think there's a waiver problem here that the appellants have because they really didn't challenge the court's ruling as to standing. So the issue wasn't fully briefed before this court because they didn't raise it in their opening brief. And so I think they've waived the right to bring the claim now. I do want to return to Judge Niemeyer's question because he questioned how some of the evidence that is related to the necessity prong and in terms of the personal animosity. There's no doubt there has been a lot of conflict between Mr. Lucy and his neighbors and including the corporation. But under the reasonable accommodation analysis, the necessity prong, of course, includes the equal opportunity component of that. The plaintiff has the burden to show that the requested accommodation is necessary to deliver an equal opportunity to persons with disabilities. And those two things, as we know from Bryant Woods and other cases, are closely tied together. When Mr. Lucy demands an accommodation that would not put some of what I think of as the business restrictions, the arbitration, the escrow, the guarantors. When he rejects those business conditions, he is asking not for an equal opportunity for persons with disabilities. He is asking to be put in a position that disregards the consequences of his own actions and the business restriction.
I will be brief. The consequences of his actions, I mean, Judge Niemeyer has been talking about, he seems very litigious, and so that's why these conditions might be appropriate. But the problem is that he's litigating, at least in part, on behalf of the FHA. That's protected conduct. And I'm hearing you basically saying, because of his protected conduct in advocating for housing for the elderly disabled, we impose these conditions. I mean, how is that not expressly retaliatory?
His initial conduct in terms of violating the restricted covenants, the architectural covenant and the business restriction covenant, was not protected activity. It was in violation of those covenants. The district court found that he was flagrantly in violation of those covenants. And at the time, that is not protected litigation activity.
Right? This is, I feel like the bad feeling is much more longstanding than that. And it's based, I mean, on your own account, it is based at least in part on, I think the way you would put it is Lucy being like bossy and unreasonable and a huge pain in the neck in his efforts to find a property in which he can build a group house for the elderly disabled. And that, like, I think that's very tricky to untangle for you because it does sound kind of like retaliation.
Well, I think that had Mr. Lucy come to the corporation from the outset and requested the accommodation before he began, the construction and the other things that led to the filing of this litigation, we might be in a different place. But he demonstrated a willingness to violate the covenants and the rules of the corporation. And that is what began the difficulty of the litigation that followed and the need to have some of those business restrictions in place.
All right, thank you.
Thank you, Your Honors.
Mr. Klepper?
Judge Niemeyer, you said the record was thin. We have the smoking gun. Joint Appendix 1831. Tuesday, June 9th, 2020. It is 2 weeks after Judge Bennett saying you're going to have to do the interactive process. It is the day before that is Mr. Lucy submits the accommodation request. And Kevin Reed, a board member, he's a member of both the club and interlocking member of the board, the GIC's board. He writes to Dave Weinberg, who is the accommodations committee chair. It hasn't been announced yet, but he says, you'll need this for your accommodation committee. And he says, the offensive part is that Lucy is marketing the island more than anything else with a clear suggestion that residents in his facility will have access to everything on the island, although he doesn't mention the club. Now, he's a member of the club. He's a member of the board. Each of them have a majority of interlocking directors.
He wasn't a decision maker, was he?
Oh, he had a vote, Your Honor. He
No,
was
the
a board
decision maker. That came much later. And
Well, Your Honor, he said that to a board member said that to the chair of the accommodations committee. Now, under a helping hand, Your Honor, it was presumed under far less, presumed as a matter of law for purpose of summary
step
judgment.
back and read this record.
Yeah.
This record looks like to me that this accommodation would have gone ahead smoothly. They would have gone ahead and made the adjustments necessary in every respect, except for the fact that they didn't want to deal with this guy and they were worried about his overstepping his bounds later and trying to prevent a litigation. Now, that's what I read between the lines.
So
But
first,
as a matter of judicial review, though, we have to review the record for what it is. And the record for what it is has a requested accommodation modified by 19 conditions. And the question is, should that have been approved?
under a helping hand, Your Honor.
And I think the answer would be, let's have the district court analyze it under our case law.
Under a helping hand, Your Honor, even if he hadn't been even if these were purely the community members, they would be attributed to the board's ultimate action unless the board rebutted that presumption. There is a presumption here. This is a board member telling the head of the accommodations committee, this is my mens rea. There is nothing on this record consistent with the FHA, and I really want to stress the Maryland Fair Housing Act. I don't want us to lose sight of that. If you want to know what the temperature of the Supreme Court of Maryland would be on this, we just look at a case very well known to the students in this room, in Ray Chavis. That was a case where the Supreme Court of Maryland departed from 2 other state Supreme Courts and how things done were across the country to say, as a matter of law, despite some disputes in the record, this accommodation, in that case, it's a law student who was seeking the same accommodations on the bar exam that he had in law school. The State Board of Law Examiners had the same expert who gets used around the country to say no and say you have to reprove your disability, and then recommends lesser accommodations for the bar exam. The Supreme Court of Maryland said no over all kinds of objections that there were disputed facts as they applied, because as a policy matter to further the purposes of the Americans with Disability Act, they set up what is essentially a presumption that whatever accommodations are received on the bar exams in law school, you will get for the bar exam. Now, that is something that is consistent with a helping hand. It is consistent with the Fair Housing Act, saying we want to provide fair housing subject to constitutional limitations. And I will tell you, Your Honor, that if this is remanded for further proceedings, Gibson Island Corporation will have won for 2 to 3 years, because they will have kept this process from beginning. And remember what Dr. Varn said. People leave Gibson Island because they have no place to go. They called him a puppet for saying that. A puppet. No one in this community, there are plenty of people in this community who agree with Mr. Lucy. And Dr. Varn said, I've worked with him for years, haven't had a problem. As soon as you stand with Lucy, you stand against the loudest people on the island who are saying no. They will have won, Your Honor, for a period of 2 to 3 years. Now is the time for bold action. We are at possibly the lowest point in decades for people who struggle with disabilities. They're being scapegoated for plane crashes right now. This is the time for this court to be bold and give every bit of relief that is justified. And if you look at the Maryland case law and the Maryland burdens, yes, we have a clear entitlement under federal law, but oh boy, do we have one under Maryland. Okay, so with that, thank you.
Thank you. We'll come down and greet counsel and then proceed on to the next case.
Thank you very much.
All right, be seated. All right, the next case we're going to hear is United States versus Moore, and we'll hear from Ms. Bichara first.
Good morning, and may it please the court. Jacqueline Bashara for the United States. The court should reverse the order dismissing the indictment because the district court's reasoning makes every traffic stop of a Black driver in Richmond unconstitutional. That finding of selective enforcement is simply not supported.
Yeah.
I'm sorry, Judge Niemeyer. That finding of selective enforcement is simply not supported on the striking facts of this case, where the officers stopped Mr. Moore's car, or attempted to stop his car, because they had seen the same fake temporary license plate 11134Y on 2 other cars earlier that night. I'll start by addressing the discriminatory purpose prong because the defendant's failure to satisfy his burden on that element of his selective enforcement claim is fatal and warrants reversal in this case. The only evidence that is specific to the 4 officers who conducted this traffic stop, Sergeant Spinos and Officers Colombo, Mills, and Williams, is that they had no discriminatory intent whatsoever. In fact, the district court made an express finding at JA 1812 that Moore presented no evidence of these 4 officers' invidious or bad faith. Simultaneously, the court made a finding that this stop was legally justified by their suspicion that he had committed a traffic offense. And so together, those rebut the inference that the district court was required to find that some kind of discriminatory animus was a motivating factor for this traffic stop. So the district court had to go beyond evidence specific to these 4 officers in order to reach its finding of discriminatory purpose. And that evidence largely falls into 2 buckets: statistical evidence and historical evidence, all of which broadly can be characterized as lacking any connection to these 4 officers who conducted the stop.
So counsel, what kind of evidence would you be looking for? Because I know you start by saying if the district court is right, then every stop of a black driver is unconstitutional. But if we reverse the district court, or do we get the opposite? No stop of a black driver is unconstitutional? Because what kind of smoking gun evidence do you think would be available?
Your Honor, it has to have some connection to the officers who actually decided to stop the car. So that's sort of our top line
Okay, but
position.
say the officers don't testify, yes, we stopped the car because the driver was black, then what?
Right. So this court's decision in Johnson, obviously no one on appeal challenged the finding or the district court's conclusion that the evidence could be used to show discriminatory intent in that case. So you would look at the particular office's pattern of stops, the racial disparity, or I guess if there is a racial disparity in that pattern of stops. Another factor that a court could consider is if the basis for the traffic violation is something that no other officer would have stopped the car for, that could also be probative of discriminatory
But
intent.
that'll be hard in Richmond, right? Because I think at least part of the evidence that you say is not connected to this stop is that they do pretextual random stops, like they stop people for very small reasons.
They do, but
So, okay, so we can rule out that
Well,
evidence.
if I could just, the raw statistical, or I'm sorry, the raw data that was available under the Community Policing Act here actually did provide the code section for each stop, or they were required to submit the code section. Obviously, there were some missing entries in this data. And so I do submit that if there was the code section cited, no other driver had, or I'm sorry, no other officer had relied on to pull over a driver, that would be probative. That an officer was really kind of going beyond the norm. I think that goes to, it sort of folds into the probable cause analysis, right? When there's really, really weak evidence of probable cause and a stronger showing of animus, that would tend to support the inference that the basis for the stop was something impermissible. But here, because we have such strong probable cause and no evidence of animus, right? That's the district court's express finding. That's why we maintain that the court's conclusion that these officers had any discriminatory purpose in making this stop is simply not supported by the record.
In terms of your statistical evidence, I think your argument is that in order for the statistical evidence to matter, there would need to be a showing of what percentage of drivers on the road all the time were white versus which percentage were black, that it wasn't enough just to show that drivers 5 to 1 or more than 5 to 1 were pulled over, the black drivers were pulled over. How would one prove then, what statistical evidence would be satisfactory in your view?
Okay.
What if
so-
it were 100 to 1? Would that be enough?
Respectfully, Your Honor, it would not be enough under Armstrong and this court's decisions in Olvis and Venable, which the evidence in those cases all involved even starker raw statistical disparities, right? So in Armstrong and actually in this court's decision in Hare as well, both of those disparities were 100%, right? all of the defendants in the respective categories were Black. Similarly, in Olvis, it was over 90% of the defendants charged in crack cases in the Norfolk and Newport News divisions of the Eastern District of Virginia were Black. And similarly, in Venable, 86.7% of the defendants charged with 922G offenses in the Richmond division of the Eastern District of Virginia were Black. So the bare fact of a statistical disparity, no matter kind of like the numerical value, that does not satisfy the defendant's burden under all precedent that I'm aware of.
Because there are two prongs. Would it satisfy one of the two prongs?
So we're talking about discriminatory purpose. I think in order to make a showing of discriminatory effect, it's clear, again, from Armstrong in this court's cases that there has to be still some showing of a similarly situated comparator. And I think maybe it would be helpful to separate out what exactly the data is that we're talking about in this case. We maintain that the most probative statistical evidence about the officer's decision to stop Mr. Moore's car here is the data about the initial stops. And there we know, because Dr. Costin testified, that there was no comparator, period. So we're not even talking about whether it was a sufficient similarly situated comparator in the initial stop data. There's just no comparator.
Wait, I'm sorry, what do you mean when you say no comparator? You just
There was no
explain that.
comparison to anything. It was just a raw statistical disparity. And I distinguish that from, for example, the heat maps, where the comparator, I guess, is the underlying 2015 to 2019 census supplement as a comparison to the rate of stops of Black drivers.
Right, what got me confused is I thought the district court almost suggested, and maybe I misread this, that comparator data would require like coming up with the names of people. That's not the government's position, is
It's
it?
not, Your
Okay.
Honor,
I
and
just-
we acknowledged in the district court that that's not the requirement,
Okay.
that aggregate statistics could be used to make this showing. The district court simply erred in, I guess, its conception of what is required to make this selective enforcement claim. A couple of other problems with the statistical data. Again, the defendant's own expert conceded that this could not show causation repeatedly throughout the evidentiary hearing, and causation is a critical component of proving discriminatory purpose on the part of these officers. And again, this data reflects citywide traffic stops. It's not specific to these officers. It's not specific to the 4th precinct. So it's pretty far removed and difficult to make any inference about what these officers intended just based on this general traffic stop data.
Can I ask you one other question about the district court opinion and purpose? I read, well, I guess I should ask you, do you believe the district court, in thinking about purpose, was asking the question you're putting in front of us now? Did these 4 officers have a discriminatory purpose? Or was the district court asking something more general, like is the stopping process, the sort of the general way Richmond police conduct traffic stops, does that have a discriminatory purpose?
Judge Harris, as I think our discussion might illuminate, it's sort of difficult to discern what another person is actually thinking in the moment. So I am not sure.
Oh, yeah, I'm guessing.
What
I'm
the
not asking
district
you-
court
I'm just-
was,
I'm not asking you to
how,
read between the lines. I'm just reading the lines. I'm
Right,
reading the opinion,
so-
and it never does say anywhere these 4 officers have
No.
a discriminatory purpose.
no. I mean, the district court made the express finding that these 4 officers did not.
Actually, if I recall, the court said something that we've got to stop this problem, sort of suggesting that the court was drawing on a personal experience or history in Richmond over a period of time, which of course doesn't implicate the 4 officers in this case, but
Right,
it
Your Honor.
does tend to suggest that maybe the court was looking beyond the horizon on that. But
Well, I think that the district court, I mean, I'm reading from the opinion, really was relying heavily on the data that was presented and in showing, in his words, a disgraceful disparity in enforcement of traffic laws, Black drivers getting the short end of the stick, and then going so far as to say that this policy or this practice prevents Black people in Richmond from going to church, school, and the grocery store without fear of the police taking them. Those are the words of the court.
would submit that the actual evidence in the record in this case doesn't support those conclusions.
So I think getting back to Sheriff's first question, what evidence would support such a conclusion under your analysis?
So now I understand that we're talking more about historical background kind of evidence. I think if there was something, first of all, more recent than 1989, and second, was specific to the Richmond Police Department, some evidence that perhaps they were using contextual traffic stops to target Black drivers. I mean, that would be really critical probative evidence of what the officers were doing in this case. But here, we just don't have anything that's connected to these officers, to the Richmond Police Department. So far removed in time, it's exactly the kind of evidence that both the Supreme Court and this court have consistently rejected as insufficient to infer discriminatory purpose.
Is that it?
Unless the court has further questions for me at this time, I can reserve the remainder of your time.
Yeah,
Thank you.
you have rebuttal. All right. Ms. Kashma.
Good morning, Your Honors. I may please the court. Rahini Tashma for Mr. Moore, who is with us today in the audience. I'd like to briefly note that we believe the district court correctly applied the tolerance standard and that decision has been foreclosed. But to the extent this court believes otherwise, the correct approach would be to vacate and remand because this is a factually intensive question and Judge Gibby was very much on the front lines. But given the government's focus on discriminatory purpose, there are no questions on the standard. I'd like to start there. So the evidence Mr. Moore proffered established that his stop was motivated in part by discriminatory purpose. So when coming to that conclusion, Judge Gibby was looking at RPD as implemented by these four officers. And as this court has recognized in Hare, where Hare was looking at the motivations of the ATF, the entity, rather than the specific undercover agents involved, the discriminatory purpose analysis isn't necessarily confined to specific people. And here it was RPD as implemented by these four officers. So
would you agree that in order to throw out the indictment in this case, the defendant would have to demonstrate that his indictment was the product of improper racial motive?
yes, Your Honor. So under Arlington,
And we're faced in this record with statements by both the expert and the district judge that the data do not support that with respect to this particular incident.
I would disagree with that. So the district court was looking at the statistical.
Well, the expert said that he could not conclude that this particular incident was motivated by race. And so did the district courts make that statement.
It is, so the it's when looking at the discriminatory purpose analysis, it's the totality of the facts. So it's not just the statistics in isolation, but it's also the pattern and conduct of these focused mission team officers that night. And all of that together permits that inference. So when we're talking about Dr. Costin's analysis, Dr. Costin was looking at the spread out of Richmond's racial demographics through census data, which is a method that the district court found was reliable. And this was an evidentiary dispute about the use of census data as a benchmark for who's on the road. And the quintessential battle of the experts that the district court found at JA 1802 that Dr. Costin's methodology was reliable, and that's a finding the government has affirmatively waived an appeal on in footnote 4 of its opening brief. Now those heat maps showed.
Well, I'm not sure there's been an agreement on that. I'm not sure we have to get into it, but the Dr. Costin basically compared the number of stops of African Americans against the population of Richmond. And the government points out that the comparison should really be a comparison of the drivers in Richmond. Otherwise, you're taking into account children who don't drive, and you take into account all kinds of other people, including other minorities, because the data also excluded Asians and Indians and these other minority groups. So I'm not sure we have to conduct a probe into whether Dr. Costin's analysis was correct, but the government has pointed out it's very suspect.
No, Your Honor, and I think maybe it would help to take a step back and look at Dr. Costa's analysis. So Dr. Costa's analysis fell into 3 buckets. So when we're talking about the use of census data as a benchmark, that was with respect to the heat maps, and whether that was reliable was something that was fully aired before the district court, and the district court found to be reliable. And what those maps showed was, if we look at figure 5 of Dr. Costin's report on JA 363, that map shows that in the 4th precinct, that precinct, which is not uniformly predominantly Black, the western side is predominantly Black, but the eastern side, which borders the predominantly white 3rd precinct, is predominantly white. But when looking at the clusters of driver stops throughout that precinct, and as figure 2 on JA 361 shows, the only clusters of drivers being stopped in the predominantly white portions of the 4th precinct were Black drivers. There are 0 clusters of white drivers being stopped throughout. And that was evidence that fed to this totality of showing how RPD has a consistent pattern of disparate treatment of Black drivers.
Counsel, can I ask you a question, and or maybe just give you a chance to respond? I mean, I found a lot of the evidence in this case very compelling, and I take your point. It seems to me that there's like a little bit of a mismatch between the evidence and then the particular remedy that is being sought, which is dismissal of an indictment. And as I think you agree, if we're talking about dismissal of an indictment, you have the defendant or the plaintiff here has to show, and that is why this happened to me. Like if this were a class action suit or, someone, I can think of other contexts, other kinds of litigation contexts in which this evidence would be extremely compelling. But I do think you have a problem with connecting this very compelling case about what is going on, big picture, with what happened to this guy this night. And it's a compound question, but there's only one other part. I am struck every time I look at this case by the fact that this doesn't actually look like a pretextual traffic stop. He didn't get pulled over for something hanging from his rearview mirror for having tinted windows. He got pulled over because the police saw the same fake license plate number being used 3 times in a row. And it does seem like, that is probably an unusual enough occurrence that probably any reasonable officer would have made this stop. So I just want to give you a chance to respond to my concern.
So to start with the first part of that question. So it's not the statistics alone, it's also what these 4 officers were doing that night. So specifically 1, pursuing Black drivers in a predominantly Black neighborhood of the not uniformly Black 4th precinct. 2, pulling over only Black drivers. They pulled over 5 people that night. All of them were Black. And 3, their disproportionate responses to these traffic infractions they were enforcing. So
they were assigned to the 4th precinct that night, right?
Yes, Your Honor, but
and the 4th precinct is I guess, predominantly Black area of Richmond, isn't it?
Not uniformly, though, Your Honor.
I didn't say uniformly, predominantly.
In the western side, but the eastern side is predominantly white. And these officers went to the predominantly Black section. And so with respect to the disproportionate responses to traffic lights, we can see in the body camera footage in this case that, for instance, the first driver, who was the dad going Christmas shopping, he forgot to turn on his headlights. And to enforce that minor traffic infraction, all 4 officers surrounded the car, shone flashlights inside to investigate the interior.
But the meaningful fact is that the officers stopped that car. The officers stopped the second one they saw and let them go. And the officers tried to stop the third one, but the third one ran. And we had a chase, right?
Yes, Your Honor, but when we're looking at...
So my point is that all 3 of them were stopped because this cardboard license number was the same identical license number. What, 11134Y, printed on cardboard, and they were all using it. And they didn't find that to be such a heavy violation that the first 2 they stopped, they gave them a chance to pull over and drive it and correct it. But the third one, the reaction of the person stopped, prompted the escalation. because he didn't stop. He ran into a curb and then ran, left the door open of his car, and a gun lying there on the floor of the car in plain view. I mean, I don't see how the fact that the officer stopped the first two supports anything.
So I think to clarify, when we're looking at the discriminatory purpose analysis, it's at the time the officers chose to make the stop. So what happened after they turned on the lights doesn't factor into that analysis. But when we look at how the officers treated the first two cars who had this duplicate tag issue, that indicates that they didn't actually think that this tag issue was serious or something that.
And they may not even on the third, but the third, the scenario was when they tried to stop the car. Unlike the first two, the driver reacted by running.
But that falls outside of the discriminatory purpose analysis, because discriminatory purpose asks about when the officers decided to turn on the lights to initiate the stop. Was that decision motivated in part by race?
Well, they saw the license plate. Isn't that a good reason? A fake license plate?
No, Your Honor. So I think this is where the distinction between probable cause and Fourth Amendment claims versus equal protection comes in.
No, we're looking at purpose. You're trying to find evidence of purpose, and you were pointing to the fact that they stopped two others who were black with the same license plate. And I'm saying that cuts just the opposite, because they stopped those two. They didn't think it was that serious a charge. Neither one of the first two got charged. They were given their explanation, and the officers accepted it. And so they go to stop the third one in the same manner, and the third one ran and wouldn't stop. And so we know the history thereafter, but my point being, it wasn't a serious charge. It's a license plate, but it's a legitimate concern. 3 cars with the same license plate number card.
However, the Supreme Court has been clear in Arlington Heights that the discriminatory purpose doesn't need to be the sole motivating. Government agencies and entities are motivated by a variety of factors. And so here, that there may have been probable cause does not foreclose the 14th Amendment challenge. But
no, it doesn't. Under Wren, you don't look at the officer's motive unless race is an issue. And the question is, from the facts of this case, it doesn't look like they were motivated by race. It looks like they were motivated by the peculiarity. They almost chuckled at it, that there were 3 license plates with identical numbers. And so they stopped all 3 in sequence. There may have been more out there. Somebody may have been printing those things up and letting people selling them or whatever. But
so I think one of the key points in this case is that the officers involved in this case are not actually focused on traffic enforcement. Their sole goal, and they admitted this in open court, is that they use these minor traffic infractions as a way to go target drivers who have they had no reason to suspect of being involved in guns and drugs.
Did the district court make findings of fact on any of these factual statements that you're putting forward here?
As in the pretextual or their use of
On purpose, did the district court find that there was discriminatory purpose? And what do we do with that fact if the district court did not?
So the district court did find that the evidence proffered met the standard for discriminatory purpose. And when looking at that totality, that included what was happening on the night. And as the district court,
The same question I asked your colleague. I couldn't find a place where the district court said this stop, these 4 officers were motivated, at least in part, by a discriminatory purpose when they made the stop. I saw the district court saying things like Richmond's stop process or stop program has a discriminatory purpose, but I couldn't, and I'm asking, if I missed something, please tell me, but do you understand the district court to have held that these 4 officers, this stop motivated in part by race?
I believe so, because the district court was looking at RPD as implemented by these officers that night.
Right, but RPD is not these 4 officers.
Correct, Your Honor, but the district court was presented with significant amounts of evidence of what was happening that night.
And then how do you explain the part where the district court said, it seemed to be a finding of fact, no bad faith or invidious motive here?
But that's not dispositive, because as this court has seen in Hare, the discriminatory purpose analysis can look at the underlying motivations of the entity. So here it was,
So you're saying he didn't have to show that these 4 officers had discriminatory purpose?
it was specifically that RPD has a consistent pattern of disparate treatment, and these 4 officers' actions that night confirm that suspicious pattern. And as we've seen through the video camera footage, it indicates that there's evidence of
But you know, this is
racially.
not a 1983 case or some kind of challenging a practice case. This was a criminal indictment, and the indictment was thrown out. And so the question was the indictment the product of a discriminatory purpose? And that link is pretty important, isn't it?
It is important, but
That's the only thing we have to answer. Was this indictment properly thrown out? Because it was motivated by an improper discriminatory purpose.
and the answer to that is, as the district court concluded, yes, because when we look at both the statistical evidence in combination with the events of that night, it shows that the focus mission team officers here were deliberately pursuing Black drivers to stop them for criminally investigative stops. And the statistics show that white drivers in Richmond are neither subjected to these stops, these criminal investigative nature stops, and they also are not stopped anywhere near as frequently as white drivers. So the government was alluding to sheer disparities, but the selective prosecution cases they were relying on, in those cases like Armstrong, the Supreme Court explained that different races were committing those crimes at different rates. But here, Dr. Costin testified both in the report and at the hearing that there's absolutely no evidence to suggest that Black drivers commit more traffic infractions than white drivers. And the district court found that Dr. Costin to be both reliable and credible. And this, so the disparity here can't be explained purely by Black drivers just running more red lights or anything like that.
The way I read the district court opinion, and maybe this is what you're saying, is like, look, we have these citywide statistics, we have the history, and just as a matter of common sense, we ought to be asking, well, like, what takes these officers out of that pattern? Like, why would, almost like a burden shifting thing. Again, I don't see anything showing that these 4 officers weren't consistent with the history, consistent with the statistical patterns. Is that sufficient?
Oh, that they were consistent?
Yeah, would that be enough to show purpose? Look, we know what's going on, big picture. And why would we think these officers and everything about this stop lines up with that big picture? So we can kind of presume they probably had a discriminatory motive.
I believe so, but we also have more than that here. We have the evidence of these officers going into a predominantly Black neighborhood, using minor infractions like forgetting to turn on headlights to stop.
Well, that's
Black
sort of what I
drivers.
mean. We have all this general evidence, not about this stop. And when you put it all together, like, why wouldn't this stop be consistent with all that general evidence?
Yes, Your Honor. And here we also have that these officers, they clearly were not interested in the duplicate tag issue, but because they saw Mr. Moore, they saw that he was Black, they knew that this was an excuse they could use to criminally investigate.
How do we
it.
know that? They were on patrol and they saw these license plates. That's the evidence. They were in patrol in the 4th precinct, and they saw these 3 license plates, and they made stops on all 3. They obviously didn't think it was that serious a violation.
Which is precisely why the selective enforcement argument is Mr.
But
Moore
the
would
fact
not have
that they
been.
made the stops in the other cases and did not charge the people suggests that they weren't out using motive to stop them just because they were, I guess they were Blacks driving with those false license plates. But well, I understand your position, though. So.
It's because they were using these infractions that they don't care about to criminally investigate Black people. And just to clarify that, affirming here does not mean that all Black drivers in Richmond will have their indictments dismissed, which is, I think, one of the government's parade of horribles. So even sure, the statistical evidence might be more generally applicable, but that was specific.
No, but I tell you what would happen. What could happen is the very same. Another stop is made in Richmond. The driver is Black, and he puts on these very same 2 reports and nothing else. and he's home free.
No, Your Honor, so in part because the.
Well, if these two expert opinions are sufficient to support throwing out this indictment, why wouldn't they be sufficient to throw out another indictment?
It is the expert opinions plus the events that happened that night. But with respect to the statistical evidence's applicability, that was confined to 2020. And as the district court recognized in its reconsideration opinion, there's significant evidence that in the years past, this disparity that we see in the 2020 analysis has dissipated over the years. So someone trying to raise this claim now would not be able to rely on the evidence presented here. But on top of this expert reports and evidence here, we do have both body camera footage and evidence of what these four focus mission team officers were doing that night, which is specifically going to a predominantly Black neighborhood, targeting Black drivers and subjecting them to criminal investigative stops. And all of that is also backed up with the statistical analysis, which shows the inverse is not true for white drivers in Richmond. White drivers are not pulled over. They are certainly not subjected to these type of criminally investigative stops. And all of that together as that totality of the facts permits the inference of discriminatory purpose to be drawn in this case, which is why the district court did not err in dismissing Mr. Moore's indictment. If there are no further questions, we would ask that you affirm.
All right, thank you, Mrs. Touchman. Mr. Bachara?
Just a couple points in rebuttal, Your Honors. I'll start with the most recent point my friend made. She suggests that there's some kind of limiting principle to the district court's decision because the district court actually combined reliance on these expert reports with the facts of what happened on the night of December 5th, 2020. That's not correct. If you look at the district court's opinion, the district court made no findings about the focus mission team, about a pattern of stops that those officers were conducting. There's nothing specific to these officers. And again, that is fatal to this claim. Another point I wanted to follow up on, Judge Harris, you had asked basically, could we impute the practices generally of the Richmond Police Department to these four officers? We know from the Supreme Court's decision in Waite and countless cases in this court like Venable, no, it has to be a showing that the decision maker in this defendant's case acted with a discriminatory purpose. So general information about the Richmond Police Department historically, or perhaps more generally in 2020, is not probative of these four officers' intent in conducting this traffic stop.
And if we agree with you on that issue of discriminatory purpose, do we even need to reach the issue of discriminatory effect?
No, you don't. You can reverse solely on discriminatory purpose, as the Supreme Court did in Baswell on the failure to show discriminatory effect in that case.
Okay.
Unless the court has further questions, we ask that you reverse and remand with instructions to reinstate the indictment. Thank you.
Ms. Tashma, were you court appointed?
No, sir, but I was brought on as pro bono counsel.
Well, thank you. Anyway, I normally like to acknowledge and credit people who are appointed by the court to serve the court, but the pro bono work is also important. We recognize that. Thank you. We'll come down and greet counsel and we'll proceed on to the next case.
I'm gonna get my stuff.
Be seated. Right, the next case we'll here is Bolden versus Baltimore Gas and Electric. Mr. Nobani, we'll hear from you.
Yes, Your Honors. Good morning, Your Honors. Eric Mubani on behalf of Mr. Bolden. This case turns on three fundamental and reversible errors the district court committed in resolving the threshold question whether Mr. Bowden exhausted his mandatory administrative remedy before filing the suit against defendant Baltimore Gas Electric. Rule 56 of the Federal Rules of Civil Procedure imposes three main obligations. First, the court must recognize that conflicting evidence creates trial questions, not judicial decisions. Second, credibility determinations through paper records are prohibited. Third, any ambiguities in the record must be resolved in favor of the plaintiff. Title VII requires that.
You agree that the issue here is whether Mr. Bolden was a joint employee of CAEI and Baltimore Gas and Electric, right?
Yes, that's one main issue.
Now, I think during discovery, in request for admissions, you admitted that he was an employee of only CAEI, and I'm wondering how should we take that admission in this litigation?
The record, that deposition record, it was kind of, at some point, Mr. Bolden admitted that even though those are separate entities, but because of the way they manage the operation of both businesses.
No, my question is, we have a formal admission made under the rules of procedure. A request for admission, and the response is that he's an employee of CAEI. And my question is, how do we take that?
He also, the witness, Mr. Bolden, also stated that even those with CAEI and BGE are separate entities, he worked for both of them. And so that CAEI is a separate entity from BGE does not really matter because of the way they carried out operations and the way they related to Mr. Bolden.
But I didn't think your case was that they were joint, that he was a joint employee. I thought you were saying it's true he didn't name both entities in his charge to the Maryland Commission, but that's okay under this exception to the naming requirement. Is that not your position?
So our position, Your Honor, isn't, and that's a legitimate question. The position is not that he did not even name. Looking at Joint Appendix, Joint Appendix 185, Your Honor. Joint Appendix 185 references defendant Baltimore Gas and Electric.
Yeah, but not in the name or.
That reference there.
Yeah, the name appears on some of his charge documents, but
Yes.
it is never identified as the person or the entity from whom your client wants relief.
Yes, Your Honor, the language there states that he says, I had only acted professionally in my time at CAEI and BGE. And this was a document that was prepared by Mr. Bowden and the intake officer. So those are not people trained, those are not lawyers. They're not trained in formal pleadings. And this court has also held in Alvarado and Board of Trustees that they cannot be held to technical exactness. So they shouldn't be the formal ways that pleadings are drafted because they're not trained.
I understand your point. Is this, the district court understood that there was no dispute that your client did not name BGE. Did you dispute this before the district court? Because I didn't see that.
Yes, Your Honor, it was the district court referred to that dispute. This was Joint Appendix 377, where the district court referenced the intake form, which was in dispute at the time. Even though the district court ruled, every part of that ruling was based on the exception as the naming requirement exception, but not based on whether they were even named in the first place.
So I think that the case we're talking about really turns on this exception to the general rule that a plaintiff is required to exhaust administrative remedies and file either with the EEOC or with the state equivalent prior to filing a Title VII case, which you're bringing. And there's this exception to that rule that some have called the substantial identity exception, and that the district court applied these 4 questions. And so I think your client needs to prove that they meet the test with regard to this exception if BG&E wasn't named in the filing before the Maryland agency. And so if we look at those 4 questions, that whether the role of BG&E could have been ascertained, were the interests of the 2 entities similar, was BG&E prejudice, could BG&E represent to your client that these 4 questions, I guess I'd like to hear from you whether or not you think your client actually, whether this test is met in this case.
Those tests are met. But to back up a little bit, that was my point. The point is even that those exceptions, the district court shouldn't have even reached those exceptions. One, because the intake form referenced BGE. That's naming requirement, satisfy the naming. Also, the notice and participation is also satisfied because if you look at the MCCR report, which is Joint Appendix 166, it references a number of officers from BGE who appeared and who testified and who were interviewed by the board. So if they were interviewed, if they gave statement to the board, then that satisfies the naming requirement. We shouldn't even get to the exception.
So you're suggesting there should be another exception? I mean, essentially what you're arguing is there should be another exception to the naming requirement in this unusual circumstance where an individual appears to testify in the case?
So you're not to clarify that further. If an individual, the party appears and testifies and gives evidence, gives testimony, gives a statement to the administrative body, then those exceptions should not apply because that satisfies the naming requirement of Title VII.
Is there a case that stands for that proposition that you're aware of?
I believe we cited some of them in our opening brief. And also to get to we cited some of those in our opening brief. Maybe I can find one before doing the rebuttal. But also the MCCR report, which references a number of the officers who attended and gave testimony. If the court also looks at the district court's earlier ruling in a motion to dismiss, it wasn't filed by this present defendant, by a defendant who was formerly in the case. The court will see that the district court relied on the MCCR report in dismissing that motion. It was dismissed because the court also said that the plaintiff exhausted his administrative remedies because those officers attended and testified and gave statements to the board.
No, the court didn't say the officers attended. The court said the complaint alleged that the officers, that some BGE employee was part of the administrative process, but that's not the same. The court is just crediting the allegation at the motion to dismiss stage. But then on summary judgment, the court says now we have the depositions and there's just no evidence of that. It didn't happen. So how do we deal with that?
So to read out a section from that, it says, the court found that the defendant actually was aware of, and in fact, was interviewed during the administrative process. This is
that on the motion to dismiss?
Yes, Joint
The court
Appendix
doesn't
17.
find facts on the motion to dismiss. In other words, whatever the court, I don't know who used the word find, whether that's your word or the court, but the court is reiterating what you alleged in the complaint and assessing whether that states a cause of action. In the motion for summary judgment, the court examines the record and assesses what was demonstrated by the parties.
I agree, Your Honor.
So the court could not be finding facts in the motion to dismiss.
But Your Honor, on summary judgment, the court should review the entire record and then draw favorable inference in favor of the plaintiff. So every document in the record should be reviewed by the court during summary judgment. The MCCR report was there, which referenced that these officers attended, were interviewed, gave statements,
But there was no evidence of that in the record, and the officer, when deposed, said, I absolutely was not there. So
Your Honor, that evidence was an affidavit, an after acquired affidavit. Your Honor, the MCCR report was dated September 23, 2020. The affidavit that challenged those statements in the MCCR report was dated January 27, 2023. It was an after acquired affidavit. They got that affidavit after. And then the court relied on that affidavit, agreed with the statements in that affidavit, which the court shouldn't have done. And so, Your Honor, as to the substantial identity test exception, which of course I know that amicus party will address that more, but Your Honor, the court relied on disputed evidence on all the factors. Factor one, if the court looks at as to whether the plaintiff could ascertain the role, could have ascertained the role of BG at the time he filed his complaint. Your Joint Appendix 231, lines 1 to 4, shows that plaintiff may have been confused about whether BG and CAEI were separate entities. Joint Appendix 387, the district court agreed that the relationship between these two entities were complicated. So if that relationship was complicated to the court, how much more a lay plaintiff? Joint Appendix 304, 1 to 22, plaintiff was also interviewed by several people from BGE, so both entities interviewed him for the job. Joint Appendix 50, which is also Joint Appendix 174, shows the joint roles of both defendants in terminating his appointment. So they discussed the termination before he was let go. Joint Appendix 323, Joint Appendix 372, all show that some BG employees supervised plaintiff's work. If plaintiff was running late, he would call some people, which included BG employees. Joint Appendix 312. Joint Appendix 344, BG employees asked plaintiff to move his seat. Joint Appendix 185, plaintiff listed both of them in the complaint in this intake form. As to factor two, Your Honor, Joint Appendix
Mr.
185.
Yeah, I think your time is up right
Yes, sir.
now, but you can bring that back up on, you have some rebuttal on this.
Okay, thank you, Your
In
Honor.
this case, you can bring it up at that point. Ms. Sharon?
Good morning, Your Honors. Chelsea Sharon for the EEOC as amicus. We are here today to ask this court to recognize the identity of interest exception to Title VII's naming requirement and to make 3 key clarifications into how the relevant factors are applied. Turning first to the existence of the exception. We note that this court has cited Bluss with approval in dicta, but has never formally recognized the
Counsel,
exception.
can I ask you,
Yes.
you describe this as a judicially created exception to Title VII's statutory naming requirement, and I think that is a fair description. And my concern is that I kind of feel like I'm hearing from the Supreme Court, judges are not supposed to run around making exceptions to statutory requirements. So where does the authority to make an exception to a statutory requirement come from?
I understand, Your Honor. We agree that there's no specific place where the text refers to this exception, but this court has long recognized that equitable exceptions to Title VII's administrative prerequisites can be made, for example, in Chaco, in looking into equitable exceptions from Title VII's timeliness requirement. And the Supreme Court, of course, took that same approach in Zipes. So it is appropriate. There is a long history of courts creating equitable exceptions in order to advance the remedial purposes of the statute.
Okay.
I mean, that's just a general principle that we should just apply whenever it's convenient.
And I'm not
I mean, in this
advocating.
case, we're in the context of the facts of this case. And I must say that when you look at it from the beginning, even beginning with the complaint here, the witnesses listed in the complaint were all witnesses that work for CAEI. And the incidents, the only incident that was attributable to BG&E and any other type of control was when they were in the call center, where you have a bunch of these contractors doing the call services, Ms. Webster told him to log out of his computer or something. He left it on or some security measure, and that was it. And she basically had charge of the whole floor at BGA's call center downtown Baltimore. And there were other contractors in that hall doing the same work. And she happened to walk by his computer and said that. Now, that's the extent of BG&E's involvement, at least as argued by Mr. Bolden. And I don't understand why all that prompts the government to come in and say we should create some kind of exception to say that he should have been allowed to now file some kind of administrative complaint against BG&E.
Well, Your Honor, I want to be clear that we don't take a position on the facts of this case and whether the exception is met.
But you're using this as a vehicle of some kind, and it's to have us create some precedent in the abstract.
Well, we do believe, Your Honor, that it would be important to take this opportunity to reaffirm the well-established precedent of the district courts in this circuit that have been relying on this exception for decades and have crafted a substantial body of case law, and to join the majority of sister circuits who have also recognized the existence of the identity of interest exception. And
couldn't a lot of this, I mean, I totally understand the impetus for all of this, but couldn't some of this be handled the way we sort of normally handle these things by saying, look, given the equitable interests here, we would construe the naming requirement very functionally, and we would read generously a charge to see if it met that functional definition of a naming requirement. And all of that we can do consistent with the terms of the statute. But I just have some apprehension about saying, but even no matter how generously construed, if you can't meet the naming requirement, that's all right, because we, as the judiciary, are going to create or continue creating an exception to the stuff that Congress said you had to do.
And I do think, Your Honor, that there is case law to support the first approach that you mentioned that we refer to in the brief, for example.
What we did in Alvarado.
And for example, the approach in cases like Kaplan and Shahada to say that the fundamental purpose of the charge is just to fairly apprise the EEOC of the discrimination alleged and the entities involved, even if not precisely named with procedural formality.
That's what we do when we read pro se complaints. We say, well, read it generously to see if it can survive a motion to dismiss. We don't say, having read it generously, it can't, so we'll make an exception to 12b-6.
And I understand that, Your Honor. I do think that that approach is an approach that we advocate could be taken in cases in order to have some flexibility with respect to the naming requirement, recognizing that it is lay people who often initiate the charge filing process. I see that my time has expired.
I'm sorry.
Thank you very much.
Thank you.
All right. I guess we'll hear now from Ms. White.
Good morning, Your Honors. My name is Lindsay White on behalf of Baltimore Gas and Electric, and I would like to discuss the substantial identity factors after I respond to several of the points that my colleagues here today have raised. As an initial matter, you're exactly right. Judge Harris, this is a judicial exception that has never been formally recognized by the Fourth Circuit, and we would submit is not appropriate to adopt here.
Well, did you say that in your brief? I thought in your brief you took like no position on it and just said, we'll assume it.
We assumed that it applied for purposes of both the lower court and here because that was the only way that the district court found that BGE may be properly.
It's just a weird posture of this case because we don't have anybody saying this exception shouldn't apply.
Well,
or I'm sorry, not shouldn't, that this exception is not valid. We ought not endorse the exception. Nobody has told us that or taken that position in this case.
Well, I would agree with Your Honor that the naming exception would serve to fill in for this purpose. And the purpose of Title VII is to provide fair notice to respondents. And contrary to what opposing counsel has said, there has been, it is not disputed that BGE was not named. In fact, there's a request for admission where Mr. Bolden clearly admits that at Joint Appendix 153, that BGE was never named in the lower proceedings before the administrative body, the MCCR. Title VII does have a broad remedial purpose, but Title VII also requires notice to the respondent. And there are several reasons for that. And that is embodied within Title VII itself. It's clearly recognized within the case law. This serves a dual purpose: to notify the charged party of the violations and to bring them before the agency to secure voluntary compliance with the law. BGE is a co-defendant with CAEI in this litigation. CAEI is bankrupt, so it has been solely BGE defending this case. The charge was filed back in 2016. BGE had no notice and, contrary to what's been argued, did not participate in the administrative proceedings. There were several references to the record, and I'd like to distill those briefly for the court. So as an initial matter, it's true at the motion to dismiss stage that our position was denied and it went to discovery. Importantly, the district court found that for purposes of this motion only, it was going to make certain factual assumptions, as of course courts do at the motion to dismiss stage. So the court allowed the parties, really Mr. Bolden, to proceed to discovery to be able to show that that he should be able to proceed against BGE. So what the court said in the motion to dismiss ruling is of no import. In addition, what the MCCR concluded is also of no import in terms of being able to credit that certain people were interviewed. There is a stray comment here that says, according to Ms. Webster, who is a BGE employee, the complainant left his computer log on. The paragraph before summarizes Mr. Bolden's complaint, which relates to Ms. Webster saying he left his computer log on. So Ms. Webster, or Ms. Duncan, as her previous name was, also submitted a declaration that she was never interviewed during the administrative process. It's also been argued that Ms. Watts was an employee of both entities. There's no support for that in the record, aside from some passing reference in the MCCR's finding that's not supported in any kind of basis. So BGE did not participate in the lower, in the MCCR proceedings whatsoever. But even if BGE did participate in the lower proceedings, that is not the same as notice as required by Title VII. Notice under Title VII is not notice that you might be a third-party witness to a charge against your contractor. Notice under Title VII is notice that you as the respondent are potentially on the hook for these violations. And it is clear that that did not happen here. In addition, there was a reference to the intake questionnaire, which is Joint Appendix 185, which was prepared by Mr. Bolden. It's true he did mention the word BGE on it, but he did not indicate any interest in holding BGE responsible for his alleged employment discrimination allegations, like he did for CAEI. And more importantly, the intake questionnaire is not served upon a respondent. It is an internal agency document that is used to generate the charge of discrimination, which was then prepared solely against CAEI and delivered to CAEI. There's also reference to the individuals that participated at the fact-finding.
Can I just ask you, because I'm actually not that familiar with how all of this works, what would happen in your construct, given the importance of notice, if this charge had very clearly said BGE and the other employer, labeled them both as defendants, but by mistake, the commission only served it on one of the employers? Like, so perhaps your client doesn't have notice, but they're named as he complied with the naming requirement. What would you say then?
Well, Your Honor, I would say that notice means notice. It means notice to the respondent that they're on the hook.
So he can't go forward with his lawsuit because the commission misserved his complaint?
I would say that he would be able to go through with his lawsuit as to the other entity.
Ooh.
That was.
But he named them. Like what?
So
you're saying he'd be on the hook if the commission misserves the charge? That would limit his rights under Title VII, that the commission made a mistake in serving it.
Your Honor, the commission's own guidance says that when there's an allegation of joint employer, which there is here, they both have to have their own charge.
Yeah, I understand that, but he named them both as in my hypothetical, he says, here are the two people I'm going to sue, BGE and then the other four initials. And then by mistake, the commission just doesn't serve it on BGE. You're telling me that cuts back on his rights under Title VII because of the importance of notice?
Yes, I do think it would, Your Honor, because he does have to sign and verify a charge under oath. So he would see that there were not two separate charges. How it would work is there are two charges with two charge numbers, and they're both served on the respondent.
But does he serve them on the respondent?
The EEOC would serve them on
Right,
the
and so if
respondent.
the EEOC makes a mistake and only serves it on one respondent, you're saying he can't sue the other respondent, even though he complied with the naming requirement. That might be right. I'm just trying to
So I think
see where you want us to go on this.
it would be an issue of whose rights have more weight here. And I do think that courts are clear that.
Well, I think the notice isn't just the technical notice. I think the whole idea of going to the agency is to promote reconciliation.
That's right.
And of course, if one company has never received notice and can't participate, you have preempted the possibility of reconciliation with that company. And it seemed to me we don't have that here, but I'm just expanding a little bit on Judge Harris's observations about the significance of lack of notice.
There are many aspects of significance of lack of notice. There's issuing litigation holds, preserving.
Is there text in Title VII that says a defendant who has not been served can't be sued? I thought it said the plaintiff can sue effectively the named defendants in the charge he filed. And if he's named them, I don't see why he can't sue them unless there's some other provision of Title VII I'm not aware of that says a defendant can, notwithstanding the language of the naming provision, any defendant who has, even if named, who has not been served by the commission may not be sued.
Well, the text itself says that Title VII requires a plaintiff to exhaust administrative remedies against the respondent.
Right.
And that failure to name a party on an EEOC
Right, but he
charge.
did name the party. In my hypothetical, he
Yeah.
named it. So where in the text does it say he can't sue them?
I would still maintain that he did not exhaust his administrative
Because the EEOC didn't. Okay.
because they haven't
I
been.
feel like you should try to find a softer position than that, but that's okay.
Assuming we do reach the GLUS, we adopt the GLUS test as the EEOC is urging, can you address the factors and why you believe the plaintiff hasn't met it? Well, I guess my first question is, who bears the burden here?
The plaintiff bears the burden.
And what,
Your
and
Honor.
what standard of proof?
I believe it is persuasion, Your Honor. I'm not actually sure
And
that that's
does the
been.
plaintiff have to meet that on all four, or is it some yes, some no, maybe some stronger, some weaker? Is that
Yes.
right? It's a balancing?
Yes, so the case law puts more impact on the second and third factors, but looks at all four factors. So the way the case is interpreted is not that you must meet all four factors.
And so on those second and third that you say are the most important, why shouldn't we find that the plaintiff's met the burden on those factors?
Your Honor, the second factor is whether under the circumstances, the interests of a named party are so similar to the unnamed parties that for purposes of obtaining voluntary conciliation and compliance, it would be unnecessary to include them in the EEOC's proceedings. It is clear that the interest of BGE and CAEI are dissimilar. BGE is the largest provider of electricity in the state. CAEI, when it was operational, provided various business services to a variety of entities.
Did BGE approve this individual's hiring and participate in the interview process?
BGE did not approve his hiring. There's testimony from Mr. Bolden that they were part of the interview process. There's no indication as to details of that aside from that he came from BGE. And Mr. Bolden did not take any depositions in this case. So, so the interest of their party, of the named party being so similar to the unnamed parties, courts look at several considerations here, none of which are present here. So there's a case, EEOC versus 1618 concepts, where it's essentially a misnaming. There are two restaurants and one has a slightly different name than the other. And you look at interrelated operations, common ownership, common management, common corporate officers, shared location, company vehicles. all of those things. None of those are present here. CAEI was headquartered in Colombia, completely separate from BGE. CAEI performed via a contract services on BGE's property. There's no common ownership, management, no shared officers. And in fact, Mr. Bolden executed a temporary worker agreement that clearly indicates that CAEI was his employer. And there is extensive deposition testimony where he testifies that he knew as of 2016 that BGE and CAEI were separate entities. So it is clear that not only did Mr. Bolden know that they were different, but the interests of the parties are not so similar that it would be unnecessary to include BGE. And in addition, BGE strongly disputes, although this is not an issue on appeal, but down below, we strongly argue that we were not a joint employer, and that's a position we certainly would have taken in the administrative stage as well.
But the test wouldn't require you to be a joint employer, simply to have, the test does not require you to be a joint employer. Isn't that right?
That's correct, but we had a separate argument for dismissal that because we were not a joint employer, which has not been appealed.
And what about the third factor?
Yes, with respect to
Didn't you
the,
say that BG&E has been defending this case throughout?
yes, CAEI has not been defending. CAEI filed for bankruptcy, so has not participated, in this
So
litigation.
isn't that what the third factor is, whether the party participated in the proceedings?
The third factor is actually whether the absence from the EEOC proceedings resulted in actual prejudice to the interests of the unnamed parties. So it looks at the participation at the administrative stage.
And BGE did not participate?
We did
in
not
that
participate. And I discussed that a little bit ago. We did not participate in, we did not submit a position statement. None of our people were interviewed. There's no evidence to the contrary other than I think a misreading of the MCCR's finding. We have a declaration from that BGE employee, Ms. Webster, that clearly says she was not interviewed. BGE did not participate in the fact finding. Mr. Bolden has admitted that. They did not participate in any settlement discussions. The parties reached a settlement that was later revoked. So BGE had no opportunity to participate, and we would submit that it was incredibly prejudicial for many reasons. It's hard to speculate what could have happened down below. There could have potentially been a settlement. There could have been evidence that Mr. Bolden reviewed on joint employer that resulted in him not electing to sue BGE. So we would submit that there was tremendous prejudice to that.
So as to prejudice, and I think you already answered this question when Judge Berner asked it, but I just want to confirm. As to prejudice, your view would be you don't have to prove that there was prejudice. If there was an administrative proceeding, you did not participate in it because you weren't named. We can kind of presume prejudice, and the plaintiff has the burden of showing why it wasn't prejudicial.
I do think that's fair. And the cases, Mr. Bolden cited to a case, Gamble versus Gamble, that found that there was not prejudice, but there, the two entities, the unnamed entity was very closely intertwined with the other entity. So their interests were very closely intertwined. It was a sheriff's office and a county of Anne Arundel County. So I think that is, perhaps under that factor where you might be able to find that there was not prejudice.
Because factors 2 and 3, I mean, we talk about this test like it's a statute or something, but it's not. It's just some stuff written in an opinion. And I'm here to say we don't always pick our words exactly right. And factors 2 and 3 look kind of like the flip side of each other to me. Like if it's either are your interests so substantial that one can represent the other, or alternatively, were you prejudiced because they're not so interrelated? It's hard for me to imagine a case where you would come out differently on those two things. They really seem to be asking mostly the same question.
Yes, I agree with that. Just very briefly, since I see I only have a few minutes left, the final factor is whether The unnamed entity is represented, that the communication should be through the named entity, and that there's no evidence of this factor whatsoever. In fact, Mr. Bolden testified that he applied for a job at BGE. He raised complaints to Brian Andrews, who is a manager for BGE. He signed a temporary worker agreement that clearly identified BGE, and he testified he knew the two different entities, who they were as of 2016.
Is that it?
Thank you. If there are no further questions, we would respectfully submit that the lower court's opinion be affirmed.
All right, thank you. Mr. Nobani?
Yes, Your Honor. So back to the issue of naming, which we reference Joint Appendix 185. Your Honor, Title VII requires only naming. That issue came up here. It doesn't require service. Plaintiff is not required to take any document and serve on the other side. It says name the respondent. And so reference to BGE is sufficient. And so if there is any, same thing applies to the MCCR report. If there's any interpretation, any different interpretation, if there's any confusion as to whether a party was named or not named, even though they were referenced, Your Honor, that wouldn't be a subject for summary judgment. It should be a trial question, not summary judgment, to determine whether the reference was even sufficient or whether the name they put was enough.
Mr. Nobani, I need to ask you, we read your briefs and we discovered there were 3 citations that were to cases that didn't exist. You filed a subsequent brief to correct one of them, which was purportedly a Supreme Court case, which didn't exist. And then you filed a new reply brief. And in that, you again cited 2 cases which did not exist. Can you tell me where you got that, those cases? Where'd you get that research?
You know, in those cases, I use different open source resources to do the research. And so I picked the one, when I corrected when I found.
I didn't quite understand that answer. You used an outside firm?
No, I used different sources. I said I used different sources. So it wasn't one source. Different sources to do the research.
I know, but the cases didn't even exist. In other words, you look them up and they're not there. So my question is that your research? Did you research that?
Yes, Your Honor, I researched the cases, but the one that I noticed, the initial one which I corrected and took out.
You corrected the Supreme Court case, which we pointed out, but then you recited 2 other cases which also don't exist. And my question is, where did you get those cases?
You know, the cases I put, as I said, I'm not looking at a particular case right now, but those were cases that were pulled from different sources, I used LexisNexis, Westlaw, I used Google to review some of the cases as well before I cited them.
And were those online services, do they use artificial intelligence?
Google doesn't really use.
No, I said, did they use any one of those sources, do they use artificial intelligence?
None uses specifically artificial intelligence. They pull information from different sources, not from one source.
All right, we'll come down and greet counsel. Let's adjourn for the day. Not greet counsel.
This honorable court stands adjourned, signed die. God save the United States and this honorable court.